Good morning, this is your Kelso Report for Monday, July 30th, and I'm your host, Clark Kelso. We only have two cases to deal with today. First, a habeas decision from the Ninth Circuit. Now, under the Supreme Court's recent decision in Martinez v. Ryan, a petitioner may establish cause for procedural default of a trial ineffective assistance of counsel claim, where the state requires the petitioner to issue that claim in collateral proceedings by demonstrating two things. First, that counsel in the initial review collateral proceeding in state court where the claim should have been raised was ineffective under the standards of Strickland v. Washington. And second, that the underlying ineffective assistance of trial counsel claim is a substantial one, which is to say that the prisoner must demonstrate that the claim has some merit. Well, in the Ninth Circuit's decision in Cook v. Ryan, the court rejected the petitioner's contention that his ineffective assistance of counsel claim fell within Martinez. The claim was based only on alleged failures by the petitioner's pretrial counsel, who represented the petitioner only for 7 months before the petitioner successfully moved to represent himself. The record showed that pretrial counsel actually was indeed actively preparing for trial in an appropriate way, and the petitioner, by moving to represent himself, accepted responsibility for preparing his own trial and sentencing hearing. Given this record, the court concluded that the ineffective assistance of counsel claim was not a substantial one. Next, we have an attorney's fees issue that arises under California labor law. Labor Code Section 98.2c states that if a party files an appeal in the Superior Court seeking review of the California Labor Commissioner's decision and is, quote, unsuccessful in the appeal, close quote, the court shall determine the reasonable attorney fees and costs incurred by the other parties to the appeal and assess that amount as a cost upon the party filing the appeal. And in particular, quote, an employee is successful on appeal if the court awards an amount greater than zero, close quote. Well, the issue before the Second District in Arias v. Cardulius was whether the attorney's fee provision applies when the employee's appeal is dismissed on jurisdictional grounds because it was untimely. And so the Superior Court never entered any judgment with any amount at all. The Second District framed the question as whether a dismissal on timeliness grounds was the equivalent to an award of zero, and it held that the two dispositions are not equivalent, since the attorney fees provision is intended to discourage unmeritorious appeals on the merits, and that policy is not furthered when the dismissal is not on the merits. The court's precise holding was that the fee-shifting provision simply does not become operative unless the Superior Court has jurisdiction to conduct a trial on the merits. And that's it for today's Kelso Report. Have a great day in the law.